What does the abortion law in India says? How abortion become controversial all over the world? So in recent days, liberals argue that abortion is a legal right. It's a matter comes under personal liberty and privacy, and every woman has the right to decide whether to abort or not. So now the controversy starts from US. In 1973 Roe vs. Wade case, the US Supreme Court ruled that every woman has the right and personal liberty to decide to whether to abort or not. But now a leaked document from the US Supreme Court reveals that the US Supreme Court want to overturn the judgment of Roe vs. Wade case. So now they want to impose more restrictions on abortion. Even the incumbent President Joe Biden and many people started opposing to the leaked document. First, we can see what is the abortion law in India says. So in 1860, the IPC, Indian Penal Code, was introduced by the British in India. So in IPC section 312 will speak about the abortion. So in India, right from the beginning, abortion is a criminal offense. So the section 312 states that the abortion is a criminal offense and it imposes some imprisonment. After India getting independence in 1960, Shantilal Committee was appointed. So Shantilal Committee going to decide whether to legalize abortion in India or not. So in 1964 Shantilal Committee submitted their report. They stated that abortion can be done in some cases. So in 1971 pertaining to the Shantilal Committee recommendation, the government framing laws, it is called medical termination of pregnancy. So the Medical Termination of Pregnancy Act was enacted in 1971 by the government of India. So they told that in some cases abortion can be done legally. So first we can see what does the medical termination pregnancy law says. So the medical termination of pregnancy law states that if the continuation of pregnancy is a great threat for the women's physical or mental health, or after the childbirth the child is suffering from any physical or mental disorders, or it is severely handicapped, so in those cases abortion can be done. So abortion can be done in MTP 1971 says that before 12 weeks, before 3 months, abortion can be done with the consultation of one doctor. But in some rare cases, if the physical or mental health disorder is identified after 12 weeks, or in some cases the rape survivors, so the abortion can be done before 20 weeks, so with the consultation of two doctors. So normal abortion can be done in 1971 MTB states that before 12 weeks. But in some cases rape survivors abortion also can be done if she is affected from any physical or mental disorder. So after that, any contraceptive failures occurring, if the protection failed, some condoms or contraceptive pills, so the woman is suffering from severe mental health due to the birth of the child or during pregnancy period, it will adapt to the only to the married women according to MTB 1971, not to the unmarried women. So in those cases abortion can be done. So this is the medical termination of pregnancy 1971 Act states. But the recent amendment was done in 2021. It states that it increases the period of the abortion from 12 weeks to 20 weeks. So a woman can, if the woman is suffering from any physical or mental health, or the child will be handicapped, or child will suffer from any physical or mental health, so it can be aborted in 20 before 20 weeks with the consultation of only one doctor. But in some cases like rape survivors or minor conceive or some physical disabilities, so in some cases the abortion can be done from 20 to 24 weeks with the consultation of two doctors. Apart from this, with the in some rare cases the abortion can be done after 24 weeks with the consultation of state medical board. In some cases like contraceptive failures, I mean the failure accidental conceive by the failure of the protection condoms or contraceptive pills, it can be applied to the unmarried women. So in 1971 they told that it can be applicable to the only to the married women, but now the MTP 2021 states that it can be applied to the unmarried women unless and until she is suffering from some mental or physical disorder, or the child is suffering from anything else. So what was the controversy behind the pregnancy? We can see about it. So in 2017, in Puttaswamy case judgment, the Supreme Court ruled that every woman has the right to life and right to personal liberty and also right to privacy, even in the reproductive rights. So every woman has the right to privacy to decide whether to abort or not without any mental disorder or any physical disorder. If she wished to abort, she can abort. So that's what the Supreme Court ruled that. But the outcome of the judgment is not included in Medical Termination of Pregnancy 2021 Act. So now many were arguing with the judgment of the court. So court said that everyone has the personal liberty and privacy to abort the child as per her wish. Why the judgment is not included to the MTP 2021? And every woman has the personal liberty to decide. Why the government is against that? So many of the people, especially the liberals, arguing that every woman has the personal right to decide whether to abort, apart from some consultation with the doctors, or in some cases like mental or physical health. So that's what now the argument is going. So that's what I want to share with you. Thank you.